just want to thank everyone for coming this afternoon. And before I introduce our speaker, you should have received an email with an affirmation and a link to the materials. If you signed up last minute and you didn't get it, I'll send it shortly after the seminar. If you had any trouble opening it, just shoot me an email and I'll get that right over to you. In order to get your credit, you have to fill out that affirmation. You put in the code word or words, which Russ will say very clearly during the lecture. Sign it and send it back to me. And I want to thank everyone from the last lecture. Everyone got me back their affirmation super fast. It was so nice and easy. I was able to get the certificates out really quickly after the lecture. So I just want to thank everyone for that. So today, Russ will be presenting top 10 ways to avoid a grievance complaint. Russ Giorno has been counsel for judicial title since 2005 and is special counsel and the director of Judicial's National Title Services Division. He began his legal career concentrating in the areas of real estate, zoning, and land use. He has represented developers, businesses, and homeowners in all facets of the land use review and approval process and has assisted in the drafting of legislation adopted by local governments. He's a member of the New England Land Title Association and has served on the grievance committee of the Westchester County Bar Association for over 8 years. He is admitted to practice in both New York and Connecticut and is a frequent lecturer for judicial title on the topics of ethics, zoning and land use, and real estate transactions. Like I said, if you have any questions, send me an email. I'm going to type my email in the chat box right now so you all have it just in case. And Russ, I'm going to leave it to you.
Okay. Thank you, Diana. Appreciate all of you for joining us this afternoon. It's great to be able to do this via Zoom so that we can get this information to you. The first thing I just wanted to do was kind of explain how we're going to go through the presentation. The presentation itself is going to go about 50 minutes, and then after that we will have about 10 minutes or more to answer any questions that you may have, and we could do it at that time. I also will take any questions that you have after the presentation. Anytime, if you want to just send me an email to rgiorno@judicialtitle.com. That's RGIORNO @judicialtitle.com. If anything comes up after the presentation that you're thinking about, or in your daily practice, if something comes up that you want to discuss with me, I'm definitely available to speak to you on any of those topics, or just give me a call. Okay, so before we actually jump into the top 10 ways to avoid a grievance complaint, I feel it right to talk about, first of all, the complaint. And the complaint itself, which the complainant would sign, and it has to be in writing, it must set forth an act of professional misconduct. And in your exhibits, you're going to see a form grievance committee complaint, which if you take a look at that exhibit 1, you're going to see it's relatively basic form. It sets forth the complainant information, talks about the attorney complained of, whether you had any contact with other agencies, if there was any court action taken by you against the attorney, and then it goes into allegations. As you can see, it's just signed. It does not have to be verified. There's no fee to file a grievance complaint. And the reason for that is New York wants this to be an easy process for a complainant, because the legal profession itself is essentially a self-governed profession. There's no ethics sheriff that goes around and is able to police attorneys for professional misconduct. So in essence, the profession relies on the public to report possible misconduct. So that being said, the complaint itself, as you can see, it's not burdensome. It's very easy to complete. And of course, once it is filed, with the grievance committee. A copy of it is sent to the attorney in which they can respond. Just a couple things to talk about if you should ever get a grievance complaint. First thing is put it down because you don't want to compile a response to the complaint in a reactionary manner. That's not going to be a good thing. So what you'd want to do first is to kind of put it down, let all those feelings subside, and then specifically review the complaint. Definitely do not contact the complainant, but review the complaint. And when you form your answer, make sure that you are chronological, be specific, add any exhibits if you have any, and most importantly is to just be honest. And equally important, don't ignore the complaint. Make sure that you do respond to the complaint. So that being said, I just wanted to kind of give you a little understanding as to the complaint process itself. So now we will jump in to the top 10 ways to avoid a grievance complaint. And these top 10 ways, they're just things that I've seen back when I was sitting on the grievance committee, issues that would come up or issues that colleagues would tend to ask me about. So I kind of compiled it in like a top 10 list. So we'll go through that, the top 10 ways to avoid a grievance complaint, which I will also call things to keep you up at night. Number one is to know your client, and very important. If your client is an individual, is this their first house purchase, or are they a sophisticated developer? And what is their level of understanding as to the transaction? Make sure that you, if necessary, explain the process of whether it's a house purchase or a house sale or whatever matter you're handling for them. Make sure they understand what's going on. It's also important to research your client. Do they have some type of an online presence? Good or bad, it's good for you to know. Gather information, an initial client interview on the phone or in the office. There are some attorneys that actually have a client intake form, which I think is very important because it's going to understand their history. That information will be transmitted to you, so you understand if they've had any prior transactions, what their experiences have been, and how much time you need to spend on explaining step by step what's happening, what will happen. Now, if your client is an entity, you need to get as much information regarding that specific entity. And you need to make sure you understand and your client understands that the entity is the client. It is not a member or a shareholder, director, officer. You are representing the entity itself. And Rule 1.13 of the New York Rules of Professional Conduct says when a lawyer is employed or retained by an organization is dealing with the organization's directors, officers, so on and so forth, the lawyer shall explain to the law that the lawyer is the lawyer for the organization and not for any of the constituents. So that's imperative for you to relay to the client that your representation is specifically as to the organization only. Now, when you get information with regards to the entity, what you're looking for are formation documents. You may be asking them for the articles of organization, if you're talking about a limited liability company, the publication, your operating agreement, which must be created within 90 days of filing the articles of organization. And the operating agreement is a very important document, especially with real estate transactions, because it is going to define specifically who the members are and who has the authority to convey or purchase the property, what specific powers they have. And unfortunately, I've had the experience of seeing a lot of LLCs not have the operating agreement created when the LLC was formed. And I think a lot of that has to do with using some third-party company that will form the company for you and provide you with the necessary materials after formation complete. And those materials, including the operating agreement, are just kind of ignored or put aside. So it's very important that you, when you're representing an entity as a client, to get all that information, to make sure that they have the operating agreement, that the company is in good standing. And if you're representing a corporation, get the information on that corporation regarding their meetings, their bylaws, review the books, and the resolutions that will authorize either the purchase or sale in that specific transaction. Now, briefly, I wanted to discuss recent amendments to the tax law and the administrative code, which creates a new recording requirement for deeds conveying title to residential real property containing 1 to 4 family dwelling units where the grantor or grantee is an LLC. So in those instances, you have an enhanced disclosure specifically for LLCs. So if you have the grantor or grantee that is an LLC and they're selling or purchasing, information needs to be disclosed as to the specific members of that LLC. And if there is, if one of the members is an entity, like a corporation or another LLC, you have to get information on that specific member as well. So in essence, you have to kind of peel away the layers until you come to a natural person. And that has to be compiled on the addendum, which is submitted with the TP 584 when the deed is recorded. The amendment does not apply to cooperatives or condominiums, so those were taken out. Okay, so number 2, always put it in writing. That's my motto, just so that there's no misunderstanding with your client when at the initial intake, after you speak to your client, send them, either provide them the retainer agreement at the initial meeting or within a reasonable time after that, so that they can sign and execute, so they can sign it and return that back to you. Whether it's a retainer agreement or a letter of engagement, you should have some memorialization of the scope of the representation and the basis or rate of the fee and expenses for which the client will be responsible. And that is Rule 1.5. When I say rule, I'm talking about the rules of professional conduct in New York State. So going further than that, the New York Code's rules and regulations also adds a requirement that you add language as to the notice of right to arbitrate. So make sure in your retainer agreement you put that in as well. Now that applies to when fees are expected to be $3,000 or greater, but regardless of that amount, I would suggest that you put that provision in your retainer agreement as well. What I also put in my retainer agreements are, and very importantly, are wire fraud cautions. I add that language in there so that there's an understanding by the client that they have to be very careful with any wires that they're going to be sending in the course of the transaction, whether it's the contract down payment or the balance due seller at closing. You want to make sure that that they are aware of the concerns with wires these days. I have an exhibit number 4, some sample wire notices that you can take a look at, and you can use one or more than one and kind of tailor one that works best for you. And I would suggest adding that into your retainer agreement, which essentially just says that not to send any wire to anyone without calling you first and verifying that the wire instructions are accurate. There have been a lot of instances where emails have been hacked, and the cyber criminal is purporting to be either a real estate broker or an attorney, and they are changing wire instructions so that a wire would be sent to their account instead of the other party. So you want to make sure that that information or that warning, that notice, is in your retainer agreement, and throughout the course of your representation of your client, make sure that they understand the importance of that. And right before or leading up to the time of any wire going out, I would definitely reiterate that to the client. Now, I do reflect one case there, which is the Milbank case. That's a case where it's an action for legal malpractice, where the defendant in that, or the plaintiff in that case, was a student at the New York College of Osteopathic Medicine. He was expelled. He went to an attorney, which is the Milbank firm, and essentially they classified or qualified or quantified what services they were going to be providing, which is very, very limited in terms of their representation of the students. Essentially, what they said is they will investigate any options that this client has as a result of being expelled from this school. And it stated that specifically what those parameters of that representation, and went further to say that they are not going to start any litigation or anything beyond the scope of what was reflected in that retainer agreement. And the court said that the attorney is not liable for failing to act outside the scope of a written retainer agreement. So that's why it's so important to have a written retainer agreement so that it reflects what you are going to do and what you're not going to do in the course of your representation of the client. Third is just say no. If something does not seem right to you, I would just say no. Of course, before you say no, you're going to want to make sure you're gathering sufficient information on the client, but a lot of times your gut feeling is correct, and if something doesn't feel right, it's probably not right, and it may be better to just say, I'm not going to represent you in that transaction. Of course, if you're in the course of the transaction, you may withdraw from representation if permissible. And Rule 1.16 is the applicable rule, which says a lawyer must decline or withdraw from representation if the client demands that the lawyer engage in conduct that is illegal or a violation of the rules of professional conduct. So if something doesn't seem right in the context of a real estate transaction where you're getting a feeling that somebody is not a true member of the LLC, or they may appear to be somebody other than what you believe them to be by virtue of maybe a different signature, something doesn't seem right with their photo identification, essentially go the next step of trying to get an understanding as to who this person is if you don't feel right about something. And take a look, gather as much information as possible. In the instance of maybe an LLC, if you're feeling that somebody is not a true member of that LLC, maybe go outside, speak to, if possible, speak to their CPA for the LLC, get an understanding through that party whether this person actually is a member, or maybe find out from the K1 schedule who the members are with regards to that LLC. So it's important, and it's really an obligation of the attorney to kind of take the extra step and kind of get an understanding of who your client is, and if there's something that doesn't seem right, to withdraw from the representation. In furtherance of that, Rule 1.2 says a lawyer shall not counsel a client to engage or assist a client in conduct that the lawyer knows is illegal or fraudulent. Rule 4.1 states, in the course of representing a client, a lawyer shall not knowingly make a false statement of fact or law to a third person. And Rule 8.4 says a lawyer shall not engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. So you have several rules that are applicable in this instance. And essentially they're saying if something is not right, that you need to take that extra step and either and just withdraw from the representation, or don't take it to begin with, because something doesn't seem right. It may be border on being fraudulent or illegal. So after you gather your information, you make the decision as to what you should be doing based on those applicable rules. Rule 1.1 says a lawyer should provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation, and a lawyer shall not intentionally fail to seek the objectives of the client through reasonably available means. A comment to that rule is, when I say comment, when I'm talking about the New York rules of professional conduct, I'm reciting the specific rules, and in addition to the rules, there's commentaries that follow each rule. And the New York rules of professional conduct is available at the New York State Bar Association's website, so you can go on their website. They have the rules along with those commentaries, as well as ethics opinions for you to take a look at. So that comment 8 to Rule 1.1 says a New York attorney should keep abreast of the benefits and risks associated with technology the lawyer uses to provide services to clients, or to store or transmit confidential information. so important these days because as an attorney, you have the obligation to safeguard your client's confidential information. So I know many of us may be working from home, so we need to make sure that that we preserve that information and we stay we have an understanding as to the technological advances that we are using and what we can use in order to protect that confidential information. So accessing information remotely, do you have a sufficient firewall? Is the internet secure? The Wi-Fi secure? That information that you are obtaining you need to make sure that that's going to be secure at all times, and that the confidential information will be protected. Fifth, so important. This subject is so important. If you print out this PowerPoint, highlight this number 5, watch your wires, because it is so important, as we kind of touched on a little bit earlier, about wires in the course of a real estate transaction. You want to make sure if you are sending a wire that you are reviewing the bank wire transfer agreement. Because if you may be asking yourself, if there's an issue with that wire, who is responsible for the errors or delays in processing those wires? And the answer to that is not the bank. So you want to make sure that you take a look at your wire request agreements from the bank that you are using, because the language there is pretty uniform. And I have some sample wire request forms in your materials, specifically if you wanted to take a look at in Exhibit 6. There are a couple of wire transfer request forms that are in there. And if you look at some of the language here, it says that the bank is only responsible for making a good faith effort to execute the payment order, and that in no event will the bank be liable for damages arising directly or indirectly if the order is executed by the bank in good faith. And it goes on to say, the bank may rely solely on the account number of the person who is to receive the wire transfer rather than the beneficiary's name. And if provided by you, on the identification number of any financial institution through which the funds are to be transferred, rather than the name of the financial institution. So in essence, what that says is that if you provide information, an account number, along with the beneficiary's name, and for some reason, when they put in the account number, a different name pops up, say you're trying to send the information to John Doe, and when they put in the account number of the bank, it comes up to Bill Johnson. They're not responsible for that, for that if they send that wire. In furtherance of that, there's Regulation J, which is also in that same exhibit, which essentially says the same thing, that a Federal Reserve Bank may rely on the number on a payment order that identifies the intermediary bank or beneficiary's bank, even if it identifies a bank different from the bank identified by the name in the payment order. So the banks are essentially having no responsibility with regards to this. So you want to make sure before you send the wire that the information is accurate. So review that request form, before the bank sends out their wires. I know the whole process of wires has been a little crazy for attorneys these days, because the banks are they're working much different in these times. I know that some banks are just have a drive-through window. Some banks are open, and some you can't send a wire unless you make an appointment with somebody at the bank. So I know you really, what you need to do is find out what their policy is, and if you have to make an appointment, make an appointment. But before you send that wire, it's so important. Review the information and make sure it's accurate. You also want to know if there are any bank waiting periods in sending those wires out. Is there a second layer of approval? If you send something out from the branch, are they sending it to another level, a regional level, which has to approve something before the wire goes out? That may delay the sending out of that wire. So you want to make sure what the bank that you're using, what their procedure is. So we talked about verifying wire instructions before sending out any wires. The material that I want you to look at is the Duran case, which essentially is it's a complaint brought by the purchasers of a condominium in New York City, who brought an action against their attorney for legal malpractice and breach of fiduciary duty. They were purchasing, actually, it was purchasing a cooperative apartment in Manhattan, and through essentially their argument was that through her negligence, she permitted cyber criminals to hack into her email system. She had an AOL account. The cyber criminals accessed her account, purported to be her, provided wiring information, and the clients, in the course of sending a down payment, sending their contract down payment, sent it to the cyber criminals account, and they ended up wiring the amount of $2 million. And so before they found out that it was the wrong account, they were unable to recover all of it. They recovered most of the $2 million down payment, but there still was about $200,000 that they were not able to recover. So that's why they filed this complaint for legal malpractice. And essentially what they said was that she should have used some other type of protections or to safeguard any information that she has, to safeguard her client's confidential information, including the wires. That by using the AOL account with any additional measures to protect that information or those email conversations, that caused their damages. So in essence, they went through other arguments that AOL, the account that she had, was vulnerable, that she didn't have a two-factor authentication system set up, which I would suggest in any email account that you have, which essentially is it will send you either some type of a code to your cell phone if there is any remote access into your email account, or some type of a different computer than what you normally would use. A lot of banks now have that two-factor authentication. There are also email accounts providers that have that similar system in place. So I would suggest doing that as well to protect your client and to make sure that that information is not susceptible to cyber criminals because they are essentially fishing for that information, or they're trolling for that information. If they have access to your email account, or if they have access to a real estate broker's account, or anyone who's involved in the transaction, they are going to be able to monitor those email communications so that they know on or about the time in which a wire will be going out. And at that time is when they strike, and they will change wire instructions so that make sure that you inform your client of that. We talked about putting information in the or notices in the retainer agreement, which I highly recommend. This is a sample phishing attempt. Again, these cyber criminals are trying to get your information. They are trying to get your username, password, or some other type of information to access your accounts. This looks like a legitimate email, but it is not. So you want to make sure that you're very wary of these type of emails. Here's one that I just received the other day. Dear valued customer, in line with our efforts to protect your email account from hackers during this pandemic, please take a minute of your time in updating your Rackspace powered email address. So you click on that, and they're going to ask for additional information. Once they get that, they may be able to access your email account, and it goes from there. So you want to make sure that you're very wary of these type of attempts, these type of issues, these type of concerns when you're dealing with your email account and potentially wire information. Communication is key. It's important that you inform your client of material developments in a matter. Keep them reasonably informed about the status of the matter, and comply with a client's reasonable request for information. The most common grievance complaint involves the attorney's failure to communicate with their client, or failure to return phone calls. We can easily communicate with our clients these days through email. Even if you're unable to return a phone call to your client, you can always shoot them an email and say, just keeping you updated, or I got your phone message, just wanted to let you know that the matter I have no new information for you, or you can explain what new information you have in the course of your representation of the client. But the important thing is to not let it go, to try and respond to your clients, that day, or within a 24-hour period, just so you're not going to snowball something into a complaint later on. Dealing with conflicts, essentially you need to be careful about conflicts at the closing table. Conflicts should be really avoided in every respect. That's my suggestion, but there are situations where you may be asked to represent the buyer and the seller. This type of representation is not per se improper, but you have to comply with Rule 1.7, which essentially says that the client has to be fully informed and consent of this type of representation, and you have to be able to maintain independent professional judgment. And if there is some type of conflict that will disadvantage the client in any way, you have to withdraw from the representation of one of those parties. There are certain per se conflicts of interest. Those are situations where you are negotiating with yourself. Those are impermissible. Even if you have consent, those are situations where you may be a real estate broker and representing one of the parties, or if you're an attorney and you have an ownership interest in the title agency that's issuing the policy. In those instances, even with consent, you wouldn't be able to resolve that conflict because essentially you're negotiating with yourself in a lot of instances. Don't show up late for a date. So important to watch your deadlines, mortgage contingencies, those dates, inspection contingency dates, time of the essence deadlines, rate lock expiration dates, all should be calendared so they're not missed. I have a desk calendar that I use as well as one on my phone so that I have backup. You don't want to be in a situation where you missed a date and you are prejudicing your client. Rule 1.3 is the applicable rule, and it says a lawyer shall not neglect a legal matter entrusted to the lawyer. Okay, at this time, I'm going to give you the code. The code is ethics, E-T-H-I-C. Ethics, E-T-H-I-C-S. The word ethics is the code. Okay, so on to 9, trust accounts. Essentially, as an attorney, you are the fiduciary of the trust account, and you have to safeguard the funds of the owner. So the applicable rule is 1.15, which we should all be familiar with because we sign on our biennial registration statement as attorneys that we have read this rule and understand it. The escrow account records have to be maintained for 7 years. The title of account has to reflect those magic words: attorney special account, attorney trust account, or attorney escrow account. If it is an IOLA account, an additional designation is required. IOLA account is an interest on lawyers account. That's where interest earned on the account goes to the IOLA Fund of New York. You have to inform the parties of what account you're using. So in the contract, you'll see there is, in the printed form contracts, residential real estate contracts, you're going to see a provision regarding the down payment, and you would put in whether you're using the IOLA account in that particular provision of the contract. If the funds that you are holding are qualified funds, you have to use the IOLA account, which means if it's something that is small in amount and it'll only be held for a short period of time, you have to use or place that deposit or that escrow into your IOLA account. Only an attorney admitted in New York can be a signatory on an escrow account. Paralegals, bookkeepers, office managers all cannot be signatories on the account. A signatory is responsible for the act of the co-signatories if a reasonable review of the records would have disclosed the conversion. In your materials, you can take a look at the Galasso case, which essentially indicated that the attorneys must maintain appropriate vigilance over their escrow accounts. It's important to protect yourself from account errors, reconcile the account, review the bank statements on phone, via phone or online to make sure that the information is correct. To avoid any mix-up, use different colored checks for your escrow account and your operating account. Regarding smartphones and remote deposit, That's another pitfall that we should all be concerned about, because I'm sure we all are aware that there is technology which allows us to deposit a check remotely just by capturing an image of that check. And the original does not have to be provided to the bank. So that is another level of concern for us, because we don't want anyone to deposit remotely one of our checks. There are situations where somebody has captured an image of a check, whether a copy was provided at a closing, and they may somebody may change the payee and deposit remotely in their account, because that type of a picture isn't necessarily imaged, or would cause some suspicion on behalf of the bank. So we want to be careful of that. There are certain things that we can do as attorneys to protect ourselves, and that is maybe get checks that have a copy or void feature, so that when an image is taken on a copier, whether it's black and white or color, it'll reflect the words void on the check, so that somebody cannot use a copy of that and try and utilize that for a remote deposit in their accounts. What you can also do is either a positive pay system or a reverse positive pay system. You can talk to that about your to your bank about, which essentially is just verifying which checks have been written, verifying that with the bank, whether it is a positive pay, which you are providing a list of checks that you've issued to the bank, or reverse positive pay, which essentially is the bank sending you the checks that have been presented, and you're advising them which ones should be cleared or not. Okay, and lastly, just be careful out there. And how you're careful out there is you become familiar with the rules, because they govern our conduct as attorneys. If you have any questions about a specific rule, there are a lot of ethics opinions that talk about specific issues, and you may want to become aware of new ethics opinions as they are issued. You can, the New York State Bar Association has a mobile ethics app, so if there's any new ethics opinions that do come out, you'll get an alert. Not everything is going to be applicable to real estate practitioners, but it's always good to know when one comes up. You can take a look at it, because every once in a while you will have something that is pertinent or applicable to real estate. Ask questions. Reach out to the New York State Bar Association or the ethics committee of your local bar association for guidance. Follow your gut. So important. If something doesn't feel right, it's probably not right. So further investigate that to make sure this is something that is proper or improper. That gut feeling is going to kind of prevent you from taking the next step. Don't take that next step unless you review the rules, or you consult with somebody and get a feeling as to whether or not this is the proper course of action. And lastly is just to know yourself. Just to be self-aware, and practice attorney self-care, meaning good mental care. Make sure that you're in the right frame of mind to represent somebody at that point in time. And if you need time, find what works for you, jogging, reading, watching a movie, and just kind of reset, just to kind of, get your bearings. And this way you can properly represent your client. It's a good thing to know yourself, whether it's representing a client or just generally in life. It's a very important quality to just know yourself and take care of yourself. And with that being said, I think that is it. Diana, thank you very much, everybody.
We had a few questions. The first one was, if you file a grievance or a complaint against a colleague, will that remain anonymous?
Yes, grievance complaints. Oh, you're talking about the actual complainant.
Correct.
I believe. Okay. Well, anyone can submit a complaint anonymously. That will be investigated regardless. And grievance complaints do remain confidential. So no one else has the ability to access those complaints other than the grievance committee themselves. And it's something that is maintained in that attorney's file, but no one has access to that. There's no public notice as to that complaint. The only time it reaches to the level of public notice is if it reaches to a level of misconduct, which is referred to the appellate division for a public proceeding. So in that instance where you have serious professional misconduct, that may come out, but otherwise it's confidential, and a complaint could be submitted anonymously as well.
Okay, so the next question we have is, can you represent a buyer or a seller as the real estate broker and the attorney?
From what I'm understanding is if you're going to have the role as the real estate broker and an attorney for one of the parties,
yes,
that is not permissible. That is, the rules classify that as something that is a per se conflict of interest. That's a situation where your financial interests are so great that regardless of your representation of a party, that you would want the deal to close. So yeah, that would not be permissible.
So my next question is, in your experience with reviewing grievances, when does not returning a client's phone calls or emails rise to the level of malpractice for an attorney? What is most common grievance committee action taken against the lawyer in question?
I personally have not seen it rise to a level of malpractice. Malpractice is a completely different standard than what you're dealing with in terms of a grievance. When you're dealing with a grievance, you're looking for professional misconduct. In that instance, you may have the attorney may be admonished. A letter of admonition or caution may go out to the attorney, warning them that what they did was wrong and not in compliance with the rules. But in terms of malpractice, essentially, to break it down, I don't want to get too involved with malpractice. You're talking about duty, breach, and damages. Duty meaning you have an attorney-client relationship, and then there was a breach of a standard of care, or your standard of representing that client, your duties to that client. And then the third is that there were damages. So not returning a client's call, I'm trying to think of a situation. I mean, there may be some situations where the end result would be some damages that have resulted as a consequence of an attorney not returning phone calls, but I would say that would be unlikely. I think really what you're looking at is more of a grievance issue or some type of violation of the rules versus a malpractice situation.
Are you aware of any bank which would put a block on remote deposits?
I am not aware of any bank that would put a block on that. I mean, it really depends on some banks don't provide that, period. They don't provide the option to do remote deposit. But in terms of the banks that do permit it, you're just going to have to really deal with it specifically with your bank. I don't know of a bank that does that, but I don't think it would be difficult for them to do that. But you really have to reach out to your specific bank to see if that is possible. I'm not aware of it, but it could be possible with some banks if they do even do the remote deposits. If they don't do it, then you could always switch to a bank that doesn't permit or doesn't allow for remote deposits at all, if that could be a solution.
Okay. The next question, I think we have 2 questions left. If one does respond to a complaint, how does one find out status of where a claim stands within the grievance committee?
If you're saying so you're saying if the complaint was filed, you want to know status during the proceedings?
I believe that's what they're asking.
Oh, okay. Well, you're going to be informed as to the result of any complaint if it rises to a level where there is misconduct. Because first, when a complaint was filed, it may not rise to a level of any professional misconduct, in which case that complaint maybe is dismissed from the initial stage. So it might not even get to the process where an attorney has to respond to it. It may just kind of be filtered out. But if it proceeds to a point where it does rise to a level of misconduct and it goes forward, passes the screening process, then the attorney has the ability to respond to that complaint. And during the course of that, you'll be advised of when the decision comes down. In terms of what happens before that, you can reach out to the grievance committee, but you may get a response saying that no decision has been made yet. But that's pretty much all that you would get in the context of that proceeding.
Okay, and the last question, if there's any questions that come up after this, we'll email you. To avoid problems with electronic transfers, do you recommend sending large amounts of funds via Federal Express or overnight mail? And how do title companies normally handle their payoffs to lenders?
We do utilize Federal Express to send payoff checks. In terms of anything that you can track, FedEx has been very reliable, so that would be one carrier that you can use. In terms of wiring, as long you can wire those payoffs, which is great, but again, you have to be wary of those situations that I discussed in the presentation, making sure that the information in the wire is accurate, and that you get confirmation that it's been received on the other side. Either way is reliable. One is more immediate than the other. It really depends on what you would like and when you want that payoff to hit on the other side.
Okay, is there anything else you'd like to add before we wrap it up? I think those are all our questions.
I just wanted to thank you for the opportunity. It was great that I was able to present this to you. Again, if you have any questions later today or down the line, feel free to email me. Thank you very much again, and stay well.
And so before the end of the day, I will send an email to every attendee just with an affirmation and the material again in case you didn't get it the first time. And once I have the affirmations, you should receive your CLE certificate shortly. So thank you again.